I don't know, it's up to you, whatever you decide, whatever's good for you. Okay, so this is the last session of the day, but it has three very interesting papers that I look forward to hearing. So the first paper is by Ignace Claes and Joke Beck. I hope I'm saying your names correctly. Ignace teaches obligations and contract law at the law faculty of the University of Ghent, and he's also a partner at the Brussels law firm as of January 2007. And Joke Beck was appointed in 2013 as a full-time lecturer at Ghent University, where she's currently active in the fields of security law and legal methodology. She's the author of numerous scientific contributions in the field of contract and security law, and has been the member of the editorial board of the, I'm not gonna try to pronounce this, of one of the law journals, since September 2014. So. Okay.
Good afternoon, ladies and gentlemen. First of all, we would like to thank the organizers of this great conference for having us Belgians here. It's really a pleasure to be here. Today we would like to talk about you, not about you, with you about loot boxes. I don't know, maybe some of you sometimes play video games or have children playing video games. What are loot boxes? Loot boxes are a kind of mystery chests. If you can say that here, you see an example from the game Overwatch. It's a chest in a video game that can be purchased by the players, and the chest contains one or more items that then can be used in the game. Now, typical for a loot box is that before opening the loot box, the player doesn't know what is in it, so it's a surprise. Now, what is in a loot box? Usually a distinction is made between two types of items. On the one hand, you have the more cosmetic items, like a new outfit for your avatar. And on the other hand, you have items that give a player a gameplay advantage. Now, in a lot of video games containing loot boxes, players have to pay to open the loot box, and that has led to a lot of criticism. First of all, a lot of players don't like video games with loot box containing items that give players a gameplay advantage. Why? Because nowadays a lot of video games are played online, and obviously when you have a video game with loot box containing such items, players that have or that spend money on such loot boxes, they have a competitive advantage against other players. So in other words, the presence of loot boxes in video games encourages players to spend money on loot boxes. Next, game developers often use all kinds of strategies to encourage players to keep on spending money on loot boxes. For instance, by collecting data of the players and then using those data to manipulate the presentation and the content of the loot boxes. And also loot boxes, they have certain similarities with gambling, and recent research has pointed out that there's actually a link between loot box use and problematic gambling behavior. Now, all these concerns, all these criticism are especially worrying because loot boxes often are present in video games that are played by children. Now, as to the similarities between loot boxes and gambling, the question arises whether loot boxes are also legally to be qualified as gambling. And up to now, in some jurisdictions, gambling authorities or gaming authorities, kind of public authorities, they have investigated whether loot boxes are legally to be qualified as gambling by investigating whether loot boxes fall under the legal definition of gambling. Now, the legal definition of gambling is not the same in every jurisdiction, so it's no surprise that the outcome of those investigations is not the same in every jurisdiction. The most radical decision up to now has been taken by the Belgian gaming authority. It investigated 4 popular video games like FIFA, Overwatch, and 2 others, and it decided that the loot boxes in those video games were gambling, and so that these loot boxes were in violation of the Belgian gambling regulation. The Dutch Gaming Authority also decided that loot boxes are gambling, but on the condition that the items that can be found in the loot boxes are tradable or can be traded outside the game. So only in that case they are legally considered gambling. A less severe position is taken by the French Gaming Authority and by the UK Gambling Authority. They think that loot boxes are gambling only if the items can be traded outside the game and if such trade is allowed by the game developer, which is only very exceptional the case. Now, also the concerns about loot boxes have led to some initiatives of the gaming industry itself. For instance, there was a new label introduced warning that a video game contains in-game purchases. But for our research, we take a different approach. We want to find out whether private law offers or can offer protection to video players that have spent money on loot boxes. So our research question for today is whether private law can offer video game players a way to claim restitution of the money that they spent on loot boxes. Now, such restitution is conceivable when the purchase of the loot box, so the contract, is an invalid. And today we will discuss 2 types or 2 grounds of invalidity of contracts. On the first place, incapacity, because a lot of loot boxes are purchased by minors, and the second ground of invalidity is illegality, and Inyas will talk about this later. But before we discuss those 2 grounds of invalidity, we first have to figure out something else, because a lot of jurisdictions, they have specific rules on gaming contracts. For instance, in the Belgian, French, and Dutch Civil Code, you have a special section on what we call gaming and betting contracts. And what are these specific rules? First rule is that gaming contracts are unenforceable. And second important rule is that no restitution is possible of money that is paid under a gaming contract. So we first want to find out whether loot boxes are to be qualified as gaming contracts, because that might have important implications for a restitution question. Now, therefore, we need to know what a gaming contract is in the sense of the relevant provisions of those civil codes. Well, a gaming contract is what we call an aleatory contract. That means that the outcome of the contract, so the result, the obligations of the parties, that depend on an uncertain event. And in the case of a gaming contract, that uncertain event is the playing of a game. Now, obviously, in case of loot boxes, that is not the case. It's not because a loot box features in a video game that it's automatically a gaming contract, because as soon as you buy, as soon as a player purchases a loot box, he doesn't have to play to determine the outcome of the loot box. So it doesn't depend, what's in the loot box, it doesn't depend on a play that has to be played after the loot box is purchased. So these rules are not applicable. I just want to add, for England, used to have similar rules, but these rules were abandoned by the Gambling Act in 2005. Since then, the Gambling Act provides that the fact that the contract relates to gambling shall not prevent its enforcement. Okay, now we go to our first ground of invalidity, incapacity. So, when a loot box is purchased by a minor, is such a contract then valid or not? Now, the general rule in most jurisdictions, it is that minors do not have legal capacity to conclude contracts. Meaning that when a contract is concluded by a minor, that the contract is voidable, and we say that it is on demand of the minor. So only the minor can ask the contract to be avoided. In some jurisdictions, such as Belgium and France, such an avoidance is only possible if the contract is at the disadvantage of the minor. That's the general rule, but the general rule has exceptions in every jurisdiction. Very, very generally, we can divide those exceptions in two groups. First of all, we have jurisdictions like Belgium, France, and England. And in those jurisdictions, minors can validly conclude contracts if it's contracts of daily life. So that they can do. And then you have other jurisdictions, like for instance the Netherlands, where minors can validly conclude contracts with the consent of their parents. Now, do loot boxes fall under these exceptions? I don't think so. It's not likely, unless, of course, the loot box is purchased with the consent of the parents. So we have to fall back to our general rule, so meaning that minors do not have the legal capacity to purchase loot boxes, so such contracts may be voidable on demand of the minor. Then the next question is, does it lead to restitution? Under some jurisdictions, this is definitely the case. For Belgium, the Netherlands, and France, restitution is an automatic consequence of the invalidity of the contract. For England, the solution is a bit more complicated. In England, a minor can only recover his money if he can establish what we call a total failure of consideration. So that means that the minor does not have received anything that he has paid for, which is not really likely in case of the loot boxes. So, first solution, but of course you can imagine that game developers are quite creative and they find ways to deal with this problem for them, but maybe I can talk about that in the discussion. I now leave the word to my colleague Ilias.
We've already heard a lot about regulation and lack of regulation or self-regulation. Self-regulation as a life jacket for regulation. I put forward another theory of private law, which we know already for a long time. And regulation might sometimes be a life jacket, I have the impression, for that theory. And that's a theory of illegality. I have prepared one slide with 3 lines. It might have been 3 slides. First of all, what does that theory of illegality entail? Illegality is a word used in English law, but in other countries, in other legal systems, we know it as the rule against contracts which violate public policy or public order, though you might already discuss about those concepts, or contracts that somehow infringe fundamental values of a given society. So the rule I would like to talk about, and which I would like then to give an application to loot boxes, is could we consider contracts with purchasing or of selling loot boxes infringe public policy, infringe public order in a way that we could ask, that the consumer could ask the nullity of a contract, that a contract could be held of no effect. Now, although this rule is fundamental and it's often in codifications, one of the first primary rules in contract law courses, it's often, well, it should be one of the fundamental rules in a contract law handbook, but it's often digged into some minor chapter. But it is always considered to be a fundamental rule. And there are two key questions. One is, what does it really mean when we say that a contract is illegal or infringes public order or infringes public policy? And I think that many of you already used the word illegal today or yesterday, referring to statutory illegality, to non-conformity with some particular statute, with some legislation, with some regulation. But what I'm interested in is much more the second limb of public policy, being the unwritten part, not the written, but the unwritten part, and those fundamental values of society which contracts should not infringe either. Contracts should not be concluded when they infringe certain mandatory legislation, but also when they infringe principles, values which are derived from external standards, external to the legal system. So that's one key question. What does it mean that a contract is illegal? It's not only when it's infringing regulation, it might also be that the contract is held invalid or has no effect if it infringes some fundamental values, and it's much debated what that, well, it's not debated. That's the strange thing. It should be debated what those fundamental values are. For example, health might be a fundamental value. Our safety is one of our first values we enshrine. Second key question is, how can we make the link between some illegal conduct and a contract? When should we derive from an illegality situation that a contract should have no effect? And there are various elements which are more or less controversial. The first one is not controversial. When the promise you make is illegal, is infringing a fundamental value, then everyone agrees that the contract should also have no effect. If you promise to murder someone, there will be no one who will say that this contract should have. There will be no one who will deny that this contract should have no effect. The second, there is already some more discussion about that. If a party making a contract has a motive that infringes fundamental values of our society, that is harmful to our society, then, according to most, it should also be the consequence that the contract is held invalid, at least if both parties are or should be aware of that purpose. If someone buys a knife at a shop, he might buy that for just making vegetables, but it might also be that he has the purpose to kill someone. Well, then that purpose might have the effect, or will have the effect, that that contract has no effect. But what I want to come at are the following ones, because these are the controversial matters and which is scarcely written about it, except for one line maybe in some good handbooks. Should we also conclude that a contract may be invalid even if there is no regulation to that in that regard, if that contract has a harmful effect for society in net? If every contract has its benefits and its disadvantages, but if the net effect is harmful or extremely harmful, there might be nuances to be made, but if the effect of a contract is harmful for society, should we then conclude that a contract is invalid? Should it have no effect? There are examples which we are confronted with in newspapers, and we think of anti-competitive arrangements. It's the effect that is considered one of the things to be considered is whether the effect of a contract is anti-competitive or not. And then the subsequent question is, if you're not sure about the effect, if it's potentially harmful in the net, is that then sufficient to encroach upon freedom of contract? You see where the debate will end up to. So that's more or less the theory of illegality or public order at stake. And then you might apply it to loot boxes, but of course my goal is not this exotic thing of loot boxes. It might be applied to many more contexts, to financial derivatives, for example. The question is, can you decide that a contract is invalid because of illegality, because of the fact that its effect is harmful for society? And let's try to apply it to loot boxes. It's a given from science, from other sciences, that it has an addictive effect, or at least that there is a link between problematic social behavior and loot boxes. So people who have been used to play in games and purchased those loot boxes in those games, they may show problematic social behavior, ending up with unemployment, bankruptcy, and depression, or even suicide. So it's clearly that there is a harmful impact of such contracts for a fundamental value in our society, health, and also all the subsequent negative effects for society on unemployment compensation and health compensation, health problems compensation, etc. Of course, the fact that something is addictive is not sufficient in our society. Alcohol is the prime example. So we will not plead for invalidity of sale of alcohol in general. There are cultural differences as well in the appraisal of fundamental principles. That's already a given. Second element which adds up to it is that those loot boxes, if they are targeted at minors, then there is maybe already a pleading for invalidity of those loot boxes. If I don't think that our society wants minors to be addicted and to show negative social behavior for later on. And this is particularly true, and that's a third element which I add up, if that happens in the context of innocent entertainment, like a video game. You purchase a video game, but you end up to have a depression or end up in bankruptcy because of being addicted in your childhood to loot boxes. But that's a very short application of that general idea of illegality, which is often forgotten, which has much more possible scope of application than loot boxes, but that's just one example I wanted to give. Thank you.
Okay, we have a few minutes for questions. Anybody? Okay, maybe we can pick them up later, after. So. Okay, our next speaker is Dr. Uri Nir, who's an assistant professor at Ono Academic College, Faculty of Law. He was also a research scholar at the University of Pennsylvania Law School and a vice dean of the Carmel Academic Center, Faculty of Law. His main research fields are contract law and tort law. Thank you.
I want first to thank the organizers for the conference. I was yesterday all the day, today most of the day. And the reason why I decided to write this paper is because I see in the social networks a lot of negative opinions, and each time there is a negative opinion about a business or a professional, we can see the reactions. And why did you write it? Please dismiss it. It might cause him problems. He will sue you. But I can never see such reactions where there is a positive opinion. And because of this problem, I decided to write it down. This is a work in progress, and you are mostly welcome to ask. And okay, many people seek and receive advice on the internet. This conclusion This conclusion may take different forms. A request for an opinion where the initiator is an individual seeking help from a professional, reading opinions posted on professional sites and on sales sites, and comments made on forums and social networks in response to other people's requests in the past. Opinions given on the internet regarding professionals and businesses can be positive or negative. Subjectively, these opinions may be trustworthy, the writer believes in their content, or be untrustworthy. Both positive and negative opinions can be objectively accurate, that is, describe reality as it is, or be inaccurate. In the pre-internet reality, opinions were generally offered to people personally familiar with the speaker, family, friends, neighbors, co-workers. Onward, from the late 80s, onward, the growing internet network has created a different reality, where opinions posted on the internet appear to all, so that most viewers are unfamiliar with the person voicing the opinion. In the past, there has been an abundance of opinion provided on internet forums. The identity of recommenders was unknown to most readers, as it was a nick that did not disclose the identity of the speaker, so that the benefit that could be derived from these recommendations was limited. Over the last decade, consultations have been taking a place increasingly on social networks, where people recommend under their own name and their own picture. Technically, consultations on social networks may take various forms. They can be conducted through a post on the wall of the person seeking advice, who names a particular professional and asks for opinion about him. They may appear in the appropriate group, such as one that brings together residents of a particular neighborhood or city, or a group dedicated to discussions on certain issue, as part of which a message may be posted requesting an opinion on a professional or business, or they can appear in a more general post where a person asks for assistance from a professional or a certain type, say a plumber. The comments often mention additional names, and under those names, more comments may appear. Another source of opinion is websites. Some of the sites allow the purchase of products, such as Amazon or Booking. Others are only price comparison sites, such as Yahoo Shopping or Shopzilla. On these sites, both positive and negative opinions appear about merchants, and readers can use them, although, unlike on the previous sites, these opinions are not provided for a specific wearing. Opinions about professionals or businesses can be positive or negative. People have different incentive to provide positive opinions. Some are provided entirely voluntarily, based on the genuine desire of the reviewer to help the reviewed. At times, the reviewed is someone familiar to the reviewer, and at other times, the person is completely foreign to him. In other cases, where the opinion is provided within a group on a social network or some website, the motive for providing the opinion is the mutual concern of group members and the desire to improve the situation, among others, based on the assumption that other members of the group will show consideration to the reviewer and assist him in turn. By contrast, another part of the so-called objective positive opinions are not trustworthy, Some of these were written on behalf of the business or the professional and were merely published under another name. At times, they were written by an employee, a friend, or a relative, or even a neutral person who was asked by the business to post the opinion with or without pay. Various tests conducted revealed that a significant portion of opinion in different areas is untrustworthy. On sites where the opinion are considered to be particularly significant, for example, on Amazon, the number of cases where fictitious opinions have been found is particularly high. At the same time, individuals have various incentives to provide negative opinions. Similarly to positive opinions, some of the negative opinions are indeed provided out of voluntary social motive, but there are opinions posted for other reasons, such as a desire to take revenge on the professional and to settle accounts with him with respect to his professional activity or unrelated to it, or a desire to benefit his business competitor, especially in the case of a market with relatively few competitors. We saw that various incentives may be behind the posting of both positive and negative, or trustworthy and untrustworthy opinions, without any legal intervention. But we live in a legalistic world, and both negative and positive opinions can lead to legal actions. In this section, we examine the options for taking legal actions under the applicable law, first in response to negative opinions, then to positive ones. When a negative opinion is published, two parties may be harmed by it: the person about whom the negative opinion was posted, and the recipient of the opinion, assuming that the opinion was untrustworthy and caused the recipient to miss out on the opportunity to make contact with the deserving professional, resulting in using the services of another, less deserving. Here we will focus on the first one. Defamation is the most relevant cause of action in a claim by the person or business in relation to which the opinion was posted. The common elements of the cause of action are defamatory content was published, and the content concerning the injured party was revealed by the throat fissure to a third party. The general definition of publicity is sufficient to include publicity on the internet as well. Two additional requirements are added to the above. The content of the post was erroneous, and it caused harm to the object of the post. The elements of the claim obtained regarding negative opinions. Another question concerned the application of the statement. Absolute defenses are irrelevant, but qualified defenses are considered. These defenses include bona fide activity under legal, moral, or social duty, and publication of legitimate person interest of the publisher or others. On the internet, with regard to the defense of having a social duty, the question may arise whether one has a duty to share with others their feelings and opinions about a professional or business, especially when these have shown objectively to be inaccurate. Certainly, there may be situations in which such a duty exists. For example, in closed group whose members interact with one another, or in the case of sites that rely on opinions, and there is an expectation from individual who based his choice of a professional on an opinion to also share his opinion with the others. Nevertheless, the relatively limited definition of the social obligation in case law indicates that it is uncommon for the defense to apply in relation to publicizing an opinion. Another protection that may be of particular relevance is that of legitimated personal interest. Here the question arises whether a person who has a negative opinion regarding a particular professional but encounters positive opinions is obligated, in response to these opinions and to protect the legitimate personal interest of the website readers, to respond to the content of the positive opinions. In this context, an old rule states that the mere desire to serve another or even to serve the society as a whole cannot constitute a defense. Therefore, it is necessary to prove that something in the manner of activity of the site or of the group has created an obligation that is beyond the mere desire to help society. Otherwise, only the truth of the opinion is examined. When we are talking about positive opinions, when we are talking about positive opinions, the most cause of action is a negligent misrepresentation. In this case, it is clear that the object of the opinion has no grounds for legal action. The main relevant cause of action on the part of the recipient of the opinion against the person is based on the doctrine of negligent misrepresentation. The usual elements of negligent misrepresentation are the defendant provided information regarding the business or transaction in which he was involved and in which he had a monetary interest. The information was incorrect. The defendant failed to act reasonably in providing the information. The plaintiff's reliance on the information was justified. The plaintiff is the person for whom the information was intended. The plaintiff relied on the information in the transaction with regard to which the information was provided. Two of the elements of negligent misrepresentation pose a spatial problem. The first element requires that the responsibility for negligent misrepresentation be only toward those for whom the post was intended. When a particular person has requested an opinion through the internet and the request appears on the site, an exemption from liability is expected with regard to all readers of the site who are not seeking such opinion, so that they constitute third party only. Nevertheless, this element has been expanded in the form of the ruling that when the message is intended for the group, each member of the group is entitled to take legal action. The application of this expansion to the reality of the site where the opinion is not returned in response to a single request is clear. Any member of the group may be considered the addressee of the message. What about a group on social networks? Does the knowledge that a group member exists who is expected to read the recommendation that is open to all group members mean that each member of the group is considered the target audience of the opinion, although the opinion was written for only one person who requested it? And in an open group, is the general audience likely to be considered the target audience? These problems may be critical in particularly large groups where the number of those who rely on the recommendation cannot be estimated. The second problematic element is that of the reliance. The test is whether, under the circumstances, the reliance of the recipient on the representation is reasonable. The question who is reasonably entitled to rely on a representation is a highly controversial one when it comes to the law of negligent misrepresentation. This element requires the existence of a spatial relationship between the provider and the recipient of the representation. Originally, contractual relationship, close to contractual relationship, quasi-contractual relationship, or trusting relationship were required between the parties. The attitude toward the requirement of a spatial relationship is not uniform, with some states have renounced it, but others insisting on the requirement. In some states, there is also a requirement for a professional or business relationship between the provider and the recipient of the representation, and such a relationship exists in a minority of cases involving the Internet. Under the liability of negligent misrepresentation, an exemption from liability is granted for an indefinite amount of time, for indefinite amount, and for an indefinite group. If we apply this qualification to our case, many posts on the Internet in general and on social networks are made in a way that takes into account that they can be read and used long after they have been written. This is the case when someone searches for information about a particular professional and uses it in a way that the author of the presentation cannot anticipate, when the information seekers are not known in advance, and may also include those who joined the group at a later stage, and in groups where the information is open to those who are not members, and it may include even those who are not members of the group. Therefore, the question of the exemption may be significant and may be granted in a large number of cases. The exemption, however, is not relevant when the plaintiff seeks the opinion himself, and he relied on it shortly after it was provided and for the purpose for which he sought it. As I have only 3 or even 2 minutes, I will say in some words. There are the question about negligent misrepresentation and the net, about the ability to rely on opinions that they are without face-to-face contact, and sometimes are even anonymous, and it also show the problem of reliance on the Internet. Now, as we can show, there is a huge imbalance between the legal attitudes toward positive and negative opinions. There is a significant relationship between consumer opinions and the decisions of a recipient of opinions. So it has a meaningful the information is very important for the one who seeks it, and the level of enforcement against negative opinions through defamation claims is very high, while we cannot sue, as we saw till now, the one who gave only a positive opinion. So we can change this situation in two ways. One is to avoid the liability for defamation for voicing opinions completely or in the net only. But it won't happen. The defamation law has different reasons, and no one will choose this option. So the other option is to impose liability on positive opinions as well, using the negligent misrepresentation torts or even the malice misrepresentation torts that I was not talking about it. We can show we can see different advantages in imposing liability on positive opinions. It might deter the people who write untrustworthy positive opinions. The speaker is the cheapest damage avoider. It may separate between positive rumors and between stories known firsthand. And of course, it may help us to balance the liability imposed for negative opinions with the one imposed for positive opinions. Okay, thank you.
Any questions right now, or take them at the end? Okay. So last but definitely not least, we have two co-authors. First is Professor Mark Laser, who's assistant professor at the Center for Law and Digital Technologies and research fellow of the Effective Protection of Fundamental Rights in a Pluralistic World Research Program and thesis coordinator for the Advanced Masters in Digital Technologies, all at Leiden University. He holds a BSc in Communications and Media Studies, an LLB and PhD from the University of Strathclyde, and is a Fellow of the Royal Society of the Arts and a Fellow of the Higher Education Academy. He has a professional background in law, in IT, in investment banking, and in journalism. Dr. Leiser's expertise is in the regulation of the internet, and his research interests are quite wide. He won the British and Irish Law Education and Technology Association Award for Best Paper, both in 2014 and 2017. His co-author, Professor Edina Harbinia from Aston University. Edina's principal areas of research and teaching are related to the legal issues surrounding the internet and emerging technologies. She's a pioneer and globally recognized expert in post-mortem privacy, which actually means the privacy of the deceased individuals. Interesting. She has published widely on aspects of internet law and regulation, has been a visiting scholar and invited speaker to universities and conferences all over the world. She holds a number of appointments and memberships outside Aston, including membership of the Advisory Council of the Open Rights Group, Senior Fellowship of the Higher Education Academy, and many more.
Have faith that it's there. Is it?
Yes.
Okay, all right, it's good.
You can't see it.
Yeah, no, I just want to make sure it was there. So, well, thank you very much for the nice introduction, and thank you to all of you for sticking around towards the end, especially the students and the organizers who've helped put this event together. It's greatly appreciated, all the hard work that you've done. A little bit of background to how this paper came about, and myself and Edina. I clearly, I think to you probably sound like I have an American accent. I lived in the US for 20 years, kind of doing my formative years. And then beyond my formative years, I kind of moved back to Scotland where I was born, and then entered into law, and that's where I met Adina, and we studied together. And then we make do the conference round in the UK. The big conference for us is a conference called Bilata, and last year's Bilata came shortly after the UK government, or one committee in the UK government, had announced that it was going to introduce a duty of care onto platforms. And it's an interesting thing being a British academic, because the framework for what you often hear about is all the things that are horrible about the internet, you know, the cyberbullying or harassment and trolling. But I have to say, when the announcement came out that there had been a paper, that the Department of Culture, Media and Sport had released was going to put a duty of care onto platforms, I can assure you there was an academic groan at the consequences of this. And Adina and I were actually at a bar, and over a gin and tonic, we decided to write a satirical paper, which was going to be a few thousand words, where we were going to make fun of the British and their kind of hang-ups on free speech and free expression. The paper was accepted by a journal, and then it went to peer review, and it was accepted by peer review, and then it was rejected by the publisher for being too controversial. So we reworded and turned our paper, which was a joke and meant to be humorous, into a proper academic article, which is available, and we've provided the link for you at the end of these slides. And ironically, we called the paper, or maybe quite apropos, we called the paper Content Not Available, because our paper was not available via traditional academic journal routes, but it has been accepted for publication and will be available in 2020 in the full academic form. So a little bit of background to this context of what actually happened in the UK Parliament. Damien Collins, who is a member of Parliament, who's the chair of the Department of Culture, Media and Sport Committee, was pretty angry at Mark Zuckerberg, to be honest with you, and decided to hold some hearings into the Cambridge Analytica scandal, the political fallout associated with psychometric testing and targeted advertising, and associated harms that we commonly associate with Facebook and other platforms. And then this is not anything new, because this has been a long time coming. In the UK, there had been a series of papers, I don't actually know how to work this now. There had been a series of papers that had come about as a result of kind of improving safety online. There had been a green paper, there had been a strategy paper, almost the summer of 2018 and 2019 were full of new reports into how we can regulate platforms and hold them accountable for a collection of harms that were associated with. The justification that the committee used was things like fake news and child abuse images, harmful content, or children accessing harmful content, the typical stuff, terrorist and extremist content. And ironically, or quite surprisingly, I think we had a look in knife crime, right? The internet's responsible for knife crime, which we started looking a little bit closer at some of the things that the paper was being said and what research it was based upon. It gives you a little bit of insight into British politics, and that there's a lot of advocacy groups and organizations that are very keen to sort of send reports to the government on this is how you reform the internet. But I think if you take a step back from those documents, you can see very clearly that they are largely based upon the fears of their constituents, not necessarily the internet at large, and there's very few groups that put forward submissions to these kind of panels and organizations that represent all of us, as opposed to small children or vulnerable people or specific groups online. So the principles of the paper are very common. They're very acceptable. I don't think anybody has a problem with saying we want to protect children, we want to protect fundamental rights, we want to protect openness and transparency. Our big problem is twofold. The creation of a new regulator, which is going to be called, or theoretically going to be called, off-web, Originally, I think the plans are going to be to give the regulation of the internet over to Ofcom, which is the broadcast regulator in the UK. And then the long-term aim is to create a new internet regulator called Ofweb. And that regulator will be able to determine, or will have the power to determine what activities and content is harmful for users. And there will be a duty of care placed on platforms, again, which I don't think is particularly new. I think Delphi versus Estonia, the case that came out of the European Court of Human Rights, was a very clear indication that the courts were willing to sort of look at duty of care for certain type of content management and regulation as a basis for platforms and how they should actually operate. But the fallout of Delphi versus Estonia and the kind of suggestion that platforms have to be active when they know that content is going to be questionable and potentially offensive to some people was that the online comment section was removed as a functionality of a small market platform. Now, to me, that's very indicative of the type of problems that you have when you have a duty of care. Now, to apply that model and put it onto Facebook or Twitter or other platforms, as I will try and explain over the next couple of slides, I think is really problematic. Now, in line with that kind of discussion, it's a shame that there's a couple of people that made comments throughout the course of today's lecture, or today's conference, because I think some of the arguments that were made might have been somewhat convincing, but I think they're kind of easily rebutted as well. And the first is the idea that the press regulator or broadcasting regulator is the model appropriate for regulating the internet. So the press council, one of the speakers made reference to. And I think this is really, really problematic. And the first one is that the first point I'd like to make about this is that broadcasting mediums are scarce. They are a finite resource where the internet is infinitely scalable and has significant users that do not have any filter on the front end. The press has developed a series of practices over hundreds of years through a negotiation with the state to get accuracy. As long as you are accurate and you take your best effort to be accurate, you don't have to be accurate. Whereas users don't have that regulatory framework that shares, that binds them on the front end of the content creation. So if you look at case law, the idea of broadcast regulation as being an appropriate model has been completely rejected by the Americans, the ACLU versus Reno, and of course in the editorial board of Pravov Dela and Shikol versus Ukraine, the courts make it very clear that it's inappropriate to use broadcasting as a regulatory model for the internet because it's a scarce resource. That people have to take positive steps when they go online to choose what content they want to see, even if it means going to Facebook. That means that there's a user choice. Whereas a broadcaster has to actually send it, and they might not have any warning of the content that is going to be shown before it goes online. So in both the American sphere and European sphere, the idea of using broadcasting as a regulatory framework has already been rejected by the European Court and the Supreme Court. So it's not really an appropriate model for using, for regulating platforms. The other part of this is that this is not anymore an independent internet if you go down that route. My colleague's going to talk a little bit more about the problems of using off-web as an independent regulator, or sort of somewhat controlled or uncontrolled by Parliament, because Parliament is very much part of determining what that content is that's harmful. It's not truly independent. And of course, there are some good things. I don't want to say that the whole proposal is bad, but there's reporting requirements and there's enforcement requirements. Now, the duty of care itself, as far as it applies to, say, something like health and safety, or environmental legislation, or environmental measures, is completely appropriate. You have a foreseeability test, you have a proximity test, and as somebody has already else mentioned, there's a policy implication of having a duty of care imposed on people. Prevention tends to be at the heart of the legal regime, that when you have a duty of care in place. And health and safety is a perfect example of that. Did you take preventative measures to prevent the accident happening? Yes, okay, then you're off the hook as far as health and safety litigation is concerned. Did you take precaution before you did some work that affected the environment, or did you think about the worst thing that could have happened? Then obviously that is a different set of regimes where the duty of care can work. But speech is different. You know, speech is not something that you actually have to go through and internalize the costs of doing so. And if you put that regulatory burden onto platforms and require them to start putting a cost-benefit analysis of certain types of speech, then the outcome can only be that they would block it. So they would block it before it goes up, or they would filter it after it has been created. And this is also, regardless of whether there is a subjective effect or harm. So if you're going to have a blocking system in place that blocks certain content going online, then that means that somebody has already determined that there's been a harm without there ever being one. That somebody realizing that certain content and speech and words are offensive, and it's beyond our cost threshold to bear, so we're going to block it before it goes up. And in UK criminal law, and I'm pretty sure your own jurisdiction, your own jurisdictions, we don't have subjective tests. It's not whether your speech hurt me, it's whether the reasonable person would find the speech as being effective. That's the UK criminal law. So there is no subjectivity into the criminal speech. And so even at European level, at the European Court, the Charter of Fundamental Rights, you find low-level protection in law. Offensive, shocking, or disturbing speech is protected speech under the European Convention. Satirical, iconoclastic, or rude speech is protected under Article 10. And that internalization of costs and the burden of duty of care would mean that platforms then have to take preventative measures to block certain content before it even gets online. Now, at this point, I think I'm going to turn it over to my colleague who's going to actually talk about the concept of harm and what the actual document defines harm. And I think you'll find that even the definitions that they use are problematic. Thank you.
Okay, so let's have a look at those 23 harms that have been explicitly identified in the paper, in the white paper, and they're nice set out in a table there. So if you have a look, you will see what we've defined here. So I would just like to quote actually the definition of harms, because I can't paraphrase this. It's really interesting, the definition of harms from the white paper. So it says that online harms are online content or activity that harms individual users, particularly children, or threatens our way of life in the UK, either by undermining national security or by reducing trust and undermining our shared rights, responsibilities, and opportunities to foster integration. So is this clear to you? And does it make a lot of sense? Even if you knew what the British values are, and they are quite well defined, and all the new citizens, for example, need to learn them and are tested on them. So based on this definition, the harms have been grouped in different categories, and we have taken the categories from the white paper as well. So the first category is clear definition, and these harms have been legislated heavily in the UK and everywhere in most countries in the world, and most of these harms are criminal offences. And in our full paper that you will have a link to and access to if you wish to read more, we have referred to specific statutes and offences around these harms. So we don't see problems around these harms. They're already criminal offences, most of them. They've been regulated, enforced in a better or less good way. So the first group with clear definition is quite fine for now, let's see. The second one, the second group is the group with a less clear definition. So cyberbullying and trolling, extremist content, activity, coercive behavior, intimidation, disinformation, violent content, etc. So you can see yourself which harms are these. So some of these have been, again, regulated already in the statutes, and some are offences. Aspects of harassment, online harassment, extremist content, some aspects of violent content and self-harm. However, not in this form. So these are not as clearly defined in statutes or
set firmly as criminal offences. So, for example, trolling is nowhere legislated nowhere as a criminal offence in English or the UK law. And, for example, intimidation is quite a vague term, you would agree, and could include very subjective harms in that context, or violent content. Is this just the violent content that's already criminalized, such as extreme pornography, for example, as a criminal offense in the UK? Or is this any violent content from a Tarantino movie or a video game? So it's quite vague. And the third group is the underage exposure to illegal content. Children accessing pornography, and we have had an attempt in Digital Economy Act recently to impose porn ID in the UK so that everyone would be age verified before viewing pornography, and that failed miserably, luckily because of the efforts of civil society and implications with privacy that this would have by what age verification actually means. So this group is, some of the harms obviously are clearly problematic, like children using social media, children under 13 or under 18 using dating apps, and some of that has been regulated by platforms themselves, not enforced properly, obviously. So you can see just from a few of these examples that there are quite a few problems in that some of the harms have been legislated, so why should we do more on them, or should we do less for some of them? And we had in the UK the Law Commission's report on communication offences recently as well, and they said that some of the harms or some of the offences go beyond what was acceptable offline, such as Section 127 of the Communications Act, that what is grossly offensive online might not be grossly offensive online and could be a criminal offence. So there is a lot of discussion around these categories and whether they actually could be and should be regulated. In addition to those 23 harms, it's not an exhaustive list, so it's an open-ended list. So the Ofweb or Ofcom, the regulator, can identify new harms, whatever they think is appropriate, and as technology develops, so they justify this by neutrality and innovations and following these interesting concepts, but they can then impose that duty of care for new harms on platforms as well. In terms of the regulation of those harms that we have seen, the paper argues for the establishment of the new regulator, or in the period before that for Ofcom, which is a telecoms and broadcast regulator in the UK, to take over this function. So the regulatory relationship would consist of Ofweb or Ofcom, the regulator, Cabinet Office, the government, and the Parliament. So it will be this tripartite relationship that you can see there. And they would espouse economically and socially just regulatory targets, again quite vague propositions in the paper. And we've also talked about in the paper the risk of slowest shipping, the convoy problem, so platforms with the most restrictive approaches to regulating content and harms would be followed by others there is a risk of that, so to censor even more. We risk that those standards would not just be standards accepted in the UK, but the UK has the ambition to lead the world in this amazing protective package of safety measures. So we've been really, especially in the satirical paper, very, very critical of that. Obviously, there are many, many issues around regulatory independence here. Even Ofcom has been criticized in this regard in terms of regulatory capture, financial, structural, and other forms of influence. And in this particular issue, we also identified avenues for influence from the Parliament, the government, and the regulatory agendas and political agendas that they espouse in certain time periods. So what do we recommend? So we've been really critical towards this paper. We haven't really liked most of it, as you can note. So what we do, what we suggest, we just don't criticize only, but we suggest some solutions or recommendations. So we suggest, ironically, to call this duty to comply with existing regulation rather than a new duty of care. Please enforce the existing laws and criminal offences, or think about reforming them, rather than this overarching compensant regulation. Also maintain general terms of legal regulatory obligations as duties that we also already have. Adequate co-regulation plus judicial oversight. That you could interpret this proposal as a form of co-regulation. However, judicial oversight is one of the issues that we identify there, and the co-regulatory model here has not been developed or explained properly. There is ambiguous evidence. So we suggest that the government conducts or commissions proper studies before they propose the reform. So they're referring to certain surveys that have not been conclusive, and the data that have been contradictory, and on ad hoc and anecdotal evidence such as big media stories around child abuse and harms, which we are concerned about. But also there are other factors that need to be looked at. We've talked a lot today about regulating content moderation and human oversight. There is so many questions for the previous speakers, but obviously there's no time to go in detail here, and there are private initiatives in this regard, as we've seen, but there's obviously a lot of room for improvement in terms of content moderation and human in the loop. Intermediate liability and the reform is inevitable in Europe. Definitely it's changing, it's going to happen. The question is how and to what extent. So do we still want to maintain the concepts, and you might have heard of those three categories of mere conduits, caching providers, and hosts in the e-commerce directive, and their different levels of liability. Is this appropriate for the internet of today, for the technology of today or not? We argue it's not, so maybe we should look at those, reforming in those. A notice and takedown or notice and action rules. So how do we reframe and rephrase these? Do we look at some models that have been recommended by the Commission recently in the tackling illegal content, or the audio and video media directive reforms, recent changes there that also impose the transparency and accountability obligations on that particular content. And we also argue that there should be a simpler set of rules for intermediate liability, potentially, again, complying with Manila principles of intermediate liability as well. So these are just, we haven't really developed those recommendations properly in this paper, so most of the paper is criticizing the proposal, but our recommendations are a smaller part of the paper, so perhaps we need to develop that further, and obviously other researchers and colleagues have worked in these areas a lot, so there is potential to reference other colleagues' works and to work collaboratively on these. So thanks very much for your attention, and again for your hospitality here. This was the last paper. There is a link to our paper if you wish to have a look and read it, and yeah, we welcome questions. Thank you.
Thank you so much. So any questions from the? Yeah.
Just how did that tripartite, the paper, how did they propose that tripartite system work?
Well, they claim it's independent, and the purpose of that is to show that it's not independent.
Right.
That the government cabinet office, it's all based on oversight, and kind of we're going to have a place at the table and a place at the table, and then the new regulator is going to be at the table hosting them. But when you map it out, you can clearly see that government is represented in the oversight of the regulator, whether it's Ofweb or whether it's Ofcom. And so if you empower Ofcom to identify new harms, and the government is at the table telling Ofweb what those new harms may be, then you would have government control and identification of a potential abuse of powers, to say the least. And I don't necessarily think that the government should be empowered to make those types of decisions because they claim that the regulator is independent, and they're not.
Other questions? Okay, I have a question to the first and the last paper. So with regard to the first paper about loot boxes, I was wondering whether if you have a game and the game has loot boxes, so it's exactly the same, but you don't pay for the loot boxes, you pay for the game. With that, I mean, so you pay a certain price for a game, but you still does the same thing. would that come under the prohibition? And if it wouldn't, that might be a way of overcoming the same problems, the same thing. And so this is for you, and for your paper, I was wondering whether you thought about the competitive effects, you know, of these increased regulation, whether they strengthen some of the players, weaken others, and so I would love your views on that.
Yes, so as to our question, I don't think that the link is as strong as in our hypothesis between the loot box behavior that is triggered by purchasing loot boxes. If you provide for a global price for the game, and so the link is not there. Okay, you open up the boxes, but you don't open up the boxes by paying money and triggering the behavior, putting money in it in order to know each time what will be in the loot box. So I would make clearly a difference between the two.
I don't think it's working.
Oh, okay. Well, I've got a nice loud voice anyway, so it's fine. Yeah, so to answer your question, competition is certainly one of the objectives of the document, was to increase competition in the marketplace. As Adina mentioned in her presentation, or her part of the presentation, there's two possible consequences of this. The first is that the norms become the highest common denominator, so whatever the tightest harms are. The second part is, anytime you have an obligation in law to create a blocking or filtering system, then it's the big players that can afford to do it, and the little players cannot participate in the marketplace. So the outcome is the opposite of the objective. It drives the small people out, which is absolutely against the objective. So we don't really touch on this in the paper because we're more talking about content moderation, but you're absolutely right. It's high-minded with the opposite effect, and this seems to be the absolute consequence of the things that the real shortcoming of the white paper is that they tick all the boxes of what they think is good, but don't think about the longer term consequences of that box ticking exercise.
Great. Go ahead. Oh, sorry. Yeah.
Thank you. First, thanks to all of you for the papers. Really interesting. I have one question for Joke and Ignace, if I pronounce it right. The violation of public order that you mentioned and you were referring to, is it an indulgence? Can it be pinned to a specific law? Is there a written positive law on this? And if so, what does it say? Because just for comparison, in Germany, we have the violation of indecency, and that's really interesting because the key question here is whether the behavior goes against the sense of decency of all of those who think just and cheaply. So I think under this definition, all of your problems could be solved more easily than I understood the situation in Belgium. So.
Okay, I have two questions. Okay. So as to the provision in Belgium, yes, we do have, for this moment, general provision that all contracts infringing public order and good morals, bonus mores, are of no effect. So it's the general provision that you will also find in the introductory part in the French Civil Code. And you have various other legal systems like the Dutch one, and then closely connected, at least according to comparative law handbooks, is the provision 138 of the German Civil Code. But whether decency is more whether you can grab the concept better by referring to the decency norm than to public policy, I think that they in effect refer to the same, being some fundamentals, fundamental values or principles of whatever you name it, of your society. And the exercise is just not made yet what that really entails in civil law. And that's what strikes me whenever I read a book. It's only an example approach with some examples of the the past, and often it's sexual immorality and personal family life. But as soon as you go to business contracts, they do not give any examples anymore. And I think there is clearly some room for application of the public policy rule. And they always presented it as evident, and that this rule implies that you should have a look at the harmful effect of a contract like you, and to look at the externalities of a contract on third parties and on society, because that's what it is about. And we are used to that in tort law. You're used to that in tort law by looking for the externalities, to look for how we should avoid certain conduct that is harmful for third parties. Why should we not do the same when we look at when we assess the validity of contracts? Because of course there is that freedom of contract that is countervailing measure, and because there is too much emphasis on regulation, specific regulation, instead of also thinking of that general rule that might be relevant, but which is more difficult to apply, clearly. Is that more or less?
Kind of, at least in Germany, I have the feeling that that is exactly the question that we try to answer with this clause. So whether it impacts the society and then whether the behavior impacts others. That's just, we frame it under the term decency or morality, but I think that's the question, and that's the answers that are given in case law.
Okay, we include German law in our analysis. Okay. Thank you.
So this is for Anita and Mark again. So they're based, by my count, there's sort of 4 kind of emerging models for content moderation, right? There's this oversight board, a company, taking on its own initiative task. There's the NetzDG Facebook law in Germany, which is a legal mandate for the company to perform that function. There's the the French approach, which is to vest power in an expedited judicial process, and then there's the UK paper that you guys I think did a very effective job critiquing. Do you have a view on which of those 4 models is superior? And I know it's a big question, but it's in the back of my mind, it's easy to poke holes in each one of them, but at the end of the day, it feels like we're going to arrive at one. Governments are moving towards those models, and so it feels like at a macro level, we need some kind of rack and stack the pros and cons across those 4 approaches. I'd love to hear what you guys think about that.
Yeah. I take a little bit of a different approach, so I'm going to cheat on your question, if I can. I think sometimes the answers are quite obvious, but one of the problems that we have in our own discipline is that there's a reliance to look for a solution within cyber law. And so the obvious answer to me is that if you have a problem with political advertising, you don't need to put a duty of care or have a Facebook Supreme Court. You regulate advertising. We have a model for the regulation of advertising. We have directives in Europe. We have the principle of subsidiarity means that we regulate advertisers at local level. We have self-regulatory models. We have electoral law that regulates advertising in political events. You could reform there and achieve the exact same effect without having to worry about the imposition of duty of care. You don't have to worry about whether the data protection regime in your country would resolve those types of psychometric testing and targeted advertising. So sometimes I think the solutions are relatively easy, but we're asking the wrong type of question. Which new models can we apply to the situation when we're not looking at the obvious answers? I think that the comments that have been made throughout the day today about antitrust and the place of competition law, particularly in Europe, are particularly apropos to regulating the size of platforms. But I don't necessarily think you have to treat companies. I think a way that you can mitigate some of the effects is by applying competition law principles to the collection of data pools. And you see this in Germany with the kind of move from separating WhatsApp data from Facebook data. So that's moving kind of the principles into new spheres, which I think is what we need these are not necessarily new inventions of law. I personally would say the French model would be my choice because it has the legitimacy of courts' involvement, and it's not self-regulation like Facebook, and it's not government control like the UK appears to be, and it's not the kind of blanket 24-hour take it down or we're going to fine you that the Germans have developed, which creates this new sort of censorship issues and concerns. I like the idea of judicial oversight at some level, so out of those choices, I would go with the French one. Do you have any comments on that?
No, for me, just there might be issues with efficiency there, obviously. And I wouldn't say that any of those is superior. They're all equally problematic, or they have some good sides. But we did recommend the core regulatory models in a way as a good model, plus judicial oversight. That's what I think.
Does that satisfy? Answer your question?
Thank you.
Okay. So thank you very much for this wonderful panel. And thank you everybody for staying until the end of the day. And now there's a dinner waiting for you outside. So enjoy.